Hello and welcome to the Circuit Clerk Presents. We've got an interesting program for you today. It's about clearing records of the past, and we have Josh Carter with the Illinois Office of the State Appellate Defender's Office here today to talk about that program. He's an expert in this field, and if anybody can answer those questions for our viewing public, Josh certainly can. Josh, let me say welcome first of all. We've had you on the show before, and I must tell you, whenever you're on, we get a ton of calls. What about this? What about this? So I'd like to address some of those questions today. Our topic is basically how to clear your record. So if you would please, I'm just going to let you roll with this. Why would somebody want their record cleared? What is the process we go through? And what we can do as circuit clerks and attorneys to help these folks.
Okay. Well, thank you once again for having me, Tony. I appreciate it. For most folks who are looking to clear a criminal record, it's about employment. Because the availability of the information is so widespread now with the internet and other avenues for obtaining it, employers almost always do background checks when they're hiring employees, and if you've got a criminal history, that is something that can very severely impact your employment prospects.
Sure.
Exactly. There are three ways to try to clear a record in Illinois. There's the expungement process, there's the sealing process. Both of those are done through the circuit clerk and through your office. And then the third way is the executive clemency or pardon process, which deals with more serious convictions typically. But generally the largest number of folks who call our office, it's because they've had problems trying to find a job. They're looking for some way of removing the record from the public domain for that purpose.
Okay, as you know, we get calls like you do every day. When I was a kid, I did something stupid. I'll give you one example. This guy is now a well-placed individual in the community, but when he was a teenager, he went out to a nature area and was shooting a gun off with his friends, not wanting to hurt anybody, but trying out a new Christmas present he got. But he was arrested for doing something with a gun. He's going, you know what, it looks bad on my record. I need that taken off. So that's the kind of thing we're talking about. That is one example, but people who have done some serious things can also have them expunged when they were from a prior bad life, so to speak.
In some cases, eligibility for expungement or for sealing depends on the person's complete criminal history.
How long do you have to wait before you should be able to consider sealing or expungement or anything like that?
Again, that will depend a little bit depending on what exactly you're talking about. As a general rule, if you get arrested today, let's say as an example, you get arrested regardless of the charge, next week it's dismissed, thrown out, over and done with, you're not found guilty, no court supervision, nothing. And you've never had any other criminal history, you could expunge that record right away. If you're placed on court supervision and again don't have any other convictions or anything, for most offenses you have to wait 2 years after the court supervision. You can't pick up any further criminal history in the meantime before you could expunge that. There are a few offenses like retail theft where court supervision actually takes 5 years after the court supervision's terminated.
And that's a common one, I might add.
It is. It's one we see a lot. But you have to complete your court supervision, then go 5 years from the end of that, again, without being convicted of anything else. And at that point, you could expunge that record.
Okay, can people can call our office or go online and find out our contact information and get a lot of answers to questions, but can they call the Appellate Defender's Office to ask these kinds of questions?
Absolutely. That's what my office does full-time.
Okay.
The legislature created us in 2004 when the sealing provisions were enacted for the first time. And you can call our office, ask questions. We can get you the forms and instructions that you need to file a petition to expunge or to seal. We can't actually represent anyone. We're informational only. Right. But we can sort of walk you to the courthouse door with the paperwork and the instructions you're going to need to get this done if you qualify.
What's the contact information? Is there an address? Is there a website that you know of, a phone number?
You can contact us toll-free. 866-431-4907 is our toll-free number. That goes to my office here in Springfield.
Okay. And that'll flash on the bottom of your screen on occasion, so don't be surprised if you don't get some calls.
Okay. Well, we'd love to have them. That's what we're there for. We also have a website, which is www.state.il.us/defender, another /exp.html. Maybe you can put that on the screen as well.
Yes,
it's
okay.
a mouthful.
I'm impressed that you remembered all.
Well, I deal with it every day. But yeah, you can contact us either by phone or go to the website and download any of the materials directly from there.
Well, let's start at the beginning. Is there some are there some crimes, we'll say, that can't be expunged?
Sure. When you talk about expungement, which again is only one of the three possible avenues, that's really, though it's one most people are familiar with, they've heard of, it's really the least available remedy. Expungement only applies to people who've never been convicted of a criminal offense.
So that's the key.
And that is the key. If you've got a conviction on your record, you're not going to be eligible for expungement. You may be eligible for sealing, and any conviction, you're eligible to apply for executive clemency. But expungement itself only applies to people who, you could have multiple cases, but you can't have been convicted of any of them. So things where you've been arrested and dismissed, found not guilty, court supervision, even the special first offender drug probations under the Cannabis Control or Controlled Substances Act. If you have those types of dispositions that are non-conviction dispositions and you've not been convicted of anything else, then you're going to be eligible for expungement. If you've got a conviction on your record, then none of your records, even those that resulted in dismissal or acquittal, can be expunged. But many things can be sealed in that circumstance.
Why don't you explain the difference between sealed and expunged?
Expunged records are actually removed and destroyed. They're taken out of the system entirely. So
no one has access to them once they're destroyed.
Generally speaking, that's correct. Your circuit clerk file is actually impounded, so it still exists, but it can only be opened upon order of the court, which is very, very rare for that to ever happen. The law enforcement records are actually destroyed, taken out. The statute gives the law enforcement agencies the option of either destroying them or actually returning them to the individual. Most just run them through the shredder and take them out of the system entirely.
That's an expungement.
That's an expungement. A sealed record will be maintained. It's still there, it exists, but it's not available to the public. So, for example, your circuit court records, the court file, will be kept under seal here where, again, unless you had a court order, nobody could access that. If you go to the arresting police agency, their records are still there, but no one outside the police department can actually view those. Same thing with the state police records. They're there, they exist. Law enforcement still has access to them, but an employer, for example, doing a background check would not get that information.
Have that. Okay. And then there's the pardon that you mentioned earlier. I would imagine that's pretty rare.
They're very difficult to get as a general rule. Pardons, any conviction in the state of Illinois, if we're talking about a conviction in state court in the state of Illinois, the governor has the constitutional authority to issue a pardon. And if the governor does that and authorizes expungement, then you can come back to the court where it occurred and have that record expunged. That applies on, for any conviction from a speeding ticket up to first-degree murder. I mean, the governor has the authority to pardon anything. But as you mentioned, it's a fairly extraordinary remedy. Yeah. And, typically, in my experience, the older the case, the more likely they'll consider it. If you have an extended period of time with no criminal history, they're generally looking at somebody who may have made a mistake a long time ago, but isn't likely to reoffend.
And has demonstrated that they've changed their ways,
exactly,
so to speak.
Exactly.
Let me ask you something. We'll probably have several viewers that say, you know what, I did something stupid as a kid or many years ago that I would like to see if it's on my record. Where do they begin?
Well, first, let me say that I get that question a lot. Well, I got arrested or I got charged. Is that on my record? The answer to that question is, unless it's been expunged or sealed, yes, absolutely. It does not ever go away automatically.
And we pride ourselves on having accurate records.
And that's something a lot of people have heard. Is that 7 years after the incident, this record magically goes away. That is not true. There is no period of time after which these things evaporate. So the answer is yes, it would be there. Now, how would you find it? Well, if you were prosecuted, if it actually got so far as to come to court, then the people to see are the folks in your office.
County? Okay.
Yeah, in whatever county it occurred. So if you were arrested here in Springfield, you get charged, you come to court here at the courthouse in Sangamon County, then you could come to the circuit clerk's office and get all the court records relating to that incident.
Right.
You would have to go to the correct county where you were prosecuted. In circumstances where someone was arrested but not formally charged, then the arresting police agency is the place to start. They will have the arrest record information. For a lot of folks who may have more than one case, maybe there's, something happened here, something happened in Chicago, there are, different counties involved, maybe very old, they may not remember exactly what was involved. You can also go through the Illinois State Police. They have a process called Access and Review, and you can have yourself fingerprinted through your local police department. The fingerprints will be submitted to the state police, and then the state police will return that information to the police department where you were fingerprinted. You can come in, review it, write down all the information. For whatever reason, you can't have a copy of it, but you can write it all down, take it with you so that you know you were arrested on such and such a date for this charge, where it occurred. And that's a good way of tracking down maybe old arrest information that somebody's not sure exactly what happened.
So the best place to start is the point of origin where you think these troubled times happened. You have the forms, we have the forms here. We will do our best, as I'm sure your office will, is to kind of direct people where to go. You had mentioned something. People don't understand that, hey, I was convicted. That's what I need taken off of my record. I don't need something that wasn't a conviction taken off of my record. Well, first of all, an arrest is not a conviction, but that arrest could keep you from getting that job. That's why it's important to have that type of thing expunged.
Sure. Yeah, a lot of people don't necessarily understand how criminal records work. And in Illinois, there is a difference between an arrest record and a record of conviction. And even sort of floating in between those are those court supervision cases where you plead guilty, but you're not technically convicted if you do everything you're supposed to. Anytime you're arrested, or even if you're not arrested, but you are later charged by the state's attorney's office with a crime, there is a record of that, and it's public information.
Right.
So unless or until that's expunged by the court, it's floating around out there. And an employer doing a thorough background check may very well find it, and it can cause you lots of problems.
Okay, we've only got a minute before we go to break, but so if they do have a conviction on their record, again, expungement is not an alternative for you, but having your court record sealed is an option.
At least in some cases. Most nonviolent misdemeanor convictions may be sealed. There is a 4-year waiting period from the end of your last sentence before you can do that. But most misdemeanor convictions do qualify. Felony convictions, it's much more limited. Class 4 felony drug possession cases and Class 4 felony prostitution cases are sealable, again, pursuant to that 4-year waiting period. More serious felony offenses, the executive clemency or pardon process is what you're going to have to look at.
Okay. You've answered a lot of questions, but we're going to come back in just another minute and answer a lot more questions, because this is really something that affects many of the people that live here in Sangamon County, and I promise we'll return with more of those answers right after this. We're talking with Josh Carter, who is an attorney with the Illinois Office of the State Appellate Defender, and we're talking about clearing criminal records. Josh, welcome back. We've talked about a lot of things, expungements, the court sealing of a record, pardons from the governor as an example. Let's talk about the process from there. People found out that they are eligible, in this instance, to have their record expunged. What happens after that? They've contacted us, they find out they're eligible. What's the next step?
Well, once you determine the eligibility, and that of course is key because, as we've talked about, not everything can be expunged or sealed. Very quickly, I probably ought to mention that if you have questions about that aspect, about eligibility, call our office and we can talk to you about it. The circuit clerk's office, as you know, can't give legal advice, and that's one thing that, a lot of times people will come to the courthouse and they'll ask, can I expunge this? Well,
and they get frustrated when we can't tell them.
That. It's not that they're trying to be difficult or anything. They can't legally answer that.
You attorneys have made sure we don't do that.
Well, the legislature certainly.
and that was the right thing to do.
So you can call our office and make that determination. Once you know that you're eligible to expunge a record or to seal a record, then the forms that need to be filled out and filed with the court are relatively simple. They're fill-in-the-blank forms. You can get those from most of the circuit clerk's offices. I know your office has them here available to anybody that comes in. You can get them through our office as well, download them from the website, or we can send them to you. You fill those out. You'll bring them to the courthouse in the county where the case occurred. Get that on file. There will be a filing fee to do that. And at that point, there's a 60-day waiting period before the court can rule on that. And a lot of people say, well, wait a minute, if I'm eligible, why do I have to wait 60 days? The answer to that is that the arresting police agency, the state's attorney's office, and the state police all have the right to review that petition and make sure that you do qualify. They can file objections if they think that you don't.
I was just going to say, they can object, and the court would weigh that before making its decision
Absolutely.
to expunge. Is that correct?
Absolutely.
You had mentioned a fee. Is there a standard fee? Does it vary?
There is not, actually. It varies a bit county to county. The average is generally for filing fees somewhere in the neighborhood of $60 to $75, but there is a bigger range than that around the state. There's also, if you're successful, you have to pay another $60. That fee goes to the state police and involves the processing of the actual expungement or sealing at that point. That fee only kicks in if you're successful. If your petition is denied, then you don't have to pay that.
Okay, if a guy's having a problem getting a job because of his past record that is expungible, he might say, I can't afford to have it expunged. What do we do for those folks?
If you can qualify as what's called an indigent person, meaning that you meet certain income and asset guidelines, then you can petition the court to waive those fees. And there is a form that you need to fill out, submit that with the petition to expunge or petition to seal, and the court will then hold off. A determination will be made as to whether or not you qualify. If the judge finds that those fees should be waived, petition moves forward as normal. If not, then you'll have to pay the filing fee or it would be dismissed. And
I will say that you have to file that pauper's petition at the same time you're filing your request for expungement. And so they'll be considered at that time. But again, the circuit clerk's office personnel can't advise you legally what to say, what to request, how to fill out the blank forms, but we do have the authority to say, you know what, you have to pay for this filing fee now, or you have to at least fill out this form and plead with the judge for his mercy, if you will. Okay, so we know how much it costs, what the process is. Let me ask you some of the common questions that we get that I'm sure you get. A lot of people say, you know what, my case was dismissed years ago. Why do I need that expunged?
Well, again, as soon as you're arrested or charged, or both in some cases, that information is all public, and employers who do thorough background checks are going to find it. And a charge, even though it was dismissed or you were found not guilty, let's say after you go to trial and the jury says not guilty, that information is still there. And if an employer sees a charge, particularly if it's a fairly serious charge, even if it's dismissed, that may still weigh on their decision making. So it's best to, if you qualify, get these records taken care of. That way you're not going to have to contend with it. An expunged or sealed record is off limits to employers, not only in terms of the availability, but the Illinois Human Rights Act actually bars employers from asking about, inquiring into, or using an expunged or sealed record in any way. And if they do so, then they face liability for that.
Then they're in trouble.
Right.
And this is a way to give somebody a second chance, essentially. If they meet the requirements, you are given a second chance by the court, basically, is what it amounts to.
Exactly. And that was, especially with the sealing provisions that came into effect a few years ago. Some people will say, well, why the 4-year waiting period before I can do that? Well, essentially, they want to see that you stay out of trouble for that period of time. If you do, then the legislature determined you ought to get that second chance, at least when we're talking about relatively minor criminal convictions in the past.
What about the person that comes up to you and says, I was wrongly arrested. I wasn't the right guy, but I still got arrested. Why should I have to pay the filing fee to take an arrest off of my record that I wasn't even the right guy?
I do get that question fairly regularly. Unfortunately, the filing fee applies. There's nothing in the statute that sort of allows you to waive that because, whether rightly or wrongly you feel you weren't arrested correctly or because your charges were dismissed later on. The filing fee does still apply unless you do qualify to waive that pursuant to the indigency finding by the court.
Well, and the same thing, we're attacking this problem from just from different angles, but it's always the same response. But you know what? I was given supervision. I was told once I got supervision and completed it, everything would be forgotten.
Supervision successfully completed means you don't have a conviction, which is a very important distinction. There's a big difference between being convicted and not being convicted. And the supervision is what may make it eligible to be expunged if you don't have another conviction on your record. So it's an important distinction. However, those records are still there, and those records even reflect the guilty plea in the case that allowed you to get court supervision. So those are extremely problematic when an employer does a background check. At the end of the supervision period, the charges are dismissed. However, though a lot of people think that the record somehow automatically goes away, that is not the case.
And you can understand how they would think that.
Absolutely. It's actually something that oftentimes in court, things get explained, but there's a lot going on. If you're not familiar with some of the legal terms and the system at all, it can get really confusing.
All right, we've talked about who's eligible, what the benefits are, what the process is, where they can get the information, and the duration of the time it takes to get this process moving, and the fees and all of that. What have we forgot? What are those questions that you get when they call your office? What have we not covered that they might be interested in now?
Well, I think we've covered most of the high points. A couple other things that certainly do come up. A lot of people will ask, do I have to have an attorney to do this? The answer to that is no, you don't have to. It's entirely up to you.
They can do pro se?
You can hire an attorney if you want to. You can file the paperwork on your own. Most people, in my experience, do file them on their own. Our office is there to try to assist people who are going to file pro se.
What kind of questions do they ask you? I mean, is this... These should be questions that you would be able to answer, I would assume, or that the individual would be able to answer because they were involved in the process. But I mean, they can come here, pick up the packet, and then can they come and see you or someone in your office and say, help me fill this out, or what?
We can't actually meet with people directly. We're not allowed to represent anyone, and because there's only myself here in Chicago and Chris Fisher, myself here in Springfield, Chris Fisher in our Chicago office, it would be wholly unfair to the other 100 counties if we're taking appointments. But you can call in and ask those questions. Mostly we deal with folks who have questions about eligibility, because it's somewhat confusing to try to determine, especially if you have more than one case, what your options might be.
Well, what are the questions they ask you on these forms?
On the forms in terms of what the forms require?
Yeah, what are they asking this person with the record to do?
You'll need to have all the case information. So the date of the arrest, what the charges were.
We can give them all that here at the county.
When your sentence ended. Yeah, the circuit clerk's records, the docket entries are usually the most useful thing because that'll have all the dates and what occurred. You'll need to know all that information. There's some personal information that you have to fill out as well, name, date of birth, identifiers that will allow them to find the right records. The case number is an important one, and again, you can get that from the court file. If you've been arrested and not formally charged, a lot of people sort of get confused on that because there isn't an existing case file here at the courthouse, if that was the circumstance. In that case, then, when the petition's filed, your office will assign a number. Most counties use an MR or miscellaneous remedy number to do that. So you can certainly file the petition. It'll just be a little bit different in terms of the process. But the forms are basically, they're just fill in the blanks with the relevant information about the case and about the individual. And then if you have any other criminal history, you generally need to disclose that as well on a separate form.
The reason I asked that question is because you said they don't need an attorney to fill out those forms, and so they are designed to where the average person can, is with a reasonable degree of education, can understand what they're asking and can put down a response that that the court would require.
That's the intent, and certainly, you can get into situations where it's a complicated scenario. If there are several cases, it may be very helpful to have an attorney, help you navigate that process. If there's an objection filed, by the state police, let's say, or the state's attorney, it may be useful to have an attorney to help you address that with the court.
And that very well might be, even though you might think that expensive, that might be the best money you've ever spent.
Absolutely, if that's what it takes to get this done. But in terms of the sort of basic, very simple, run-of-the-mill case, the process is designed for people to be able to do it on their own. And again, our office exists not to represent those folks, but we can answer basic questions. So if you have a question about the forms, if you have a question about, I don't know where to go to file this, or anything along that line.
How long does it take, whatever.
You can call in, we can try to answer those and make sure you know what you're doing.
Now, I know there are organizations like the Illinois State Bar Association where if you're having trouble obtaining an attorney, they have different programs that they offer, as do other states have their programs. programs. But if you can't afford an attorney, obviously there's ways to find assistance with that by calling the State Bar Association. I hear them advertised on the radio all the time. And come here, we can help you. We can't answer legal questions.